Here we get to some interesting estate law updates. This is, I think, long time coming and very welcomed in the estates community. Estates law is something that changes very, very slowly. A lot of the laws that we have are, hundreds of years old that still apply today. So these updates were, again, the first bit of updates in a long time. As number one, I would say the most important one, number 1 and 2, marriage no longer revokes your will. Previously, if you got married, all the previous estate planning that you did was revoked, annulled, and you had to go and make a new will. Number 2, quite crucial as well, separated spouse no longer have a right to their former spouse's family property, estate. Like that example I gave, people are separated for a long time, and then if they were to die, their separated spouse would receive their estate. Here, since January 1st, that is no longer the case. And I think that is a very, very important change. And those two changes, number 1 and 2 there, were made to reflect society's reality. Society got married, divorced, separated, all these things, and the estate couldn't keep up. And then there were unintended consequences. So those changes to marriage and separation, I think, address those issues or commonalities in society and protect people at the end of the day. But nonetheless, a will could trump that, and a will allows you to determine and not leave it to the safety net of the law. A couple of things. Number 3 over here is currently in flux. This is a point of law that was generally accepted, that registered assets, and the registered assets are quite similar to joint tenancies in that previously registered assets are your RSPs, your TFSAs, your insurance policies, and your jointly held property. Till recently, that was automatically transferred to the remaining joint tenant. And if it was to an adult child, like I said, the settled law was that it was held in trust, a resulting trust for the estate of the parents. A couple of things. The Kalumsky decision extended that presumption of a resulting trust to registered assets, to a RIF, registered income fund. And that is, again, not what people had in mind. Usually registered assets go directly to the beneficiary. This case questioned that. There was a subsequent case, Mac Estate, where they declined to follow the Kalumsky decision and chose not to insert the presumption of a resulting trust, so that the beneficiary on the RIF, in fact, receives it. It goes directly to the beneficiary. So I titled it over here, a deadlock at the Superior Court. Right now, there's 2 conflicting decisions. Unfortunately, neither decision was appealed, so there's a bit of gray area there. And the whole point there is that you need to confirm your beneficiary designations. When we do estate planning over here, the one thing that always catches people off guard is when we get to confirming beneficiary designations. And you ask simple questions like, who's the beneficiary of your RSP, of your TFSA? And people always have to confirm that, they're not sure. But those decisions, those determinations, who the beneficiary is, are crucial in your estate plan. Without having taking those into consideration, your estate plan could be lopsided. So having those as part of the picture, the registered plans, the registered assets are important. And then how to determine how to distribute those to the next generation. Again, you don't want to leave it to the law over here because it's in flux, it's unknown. It's something that people have to confirm as part of their estate planning. Another update over here, wills cannot yet be signed electronically, but they can be signed by counterpart. So in British Columbia, they can be signed digitally, which is quite a development, but not yet in Ontario. Ontario, you still need wet ink signatures on the documents. It's one of those, I think the only thing that still requires wet ink signatures. Real estate transactions, as some of the lawyers here know, are all digital. We can sign electronically, the whole process beginning to end. Wills still need that wet signature. signing by counterpart, I find more burdensome than helpful. What that is two different identical copies of the will are signed, and then one by the witness, myself here, and then the testator, whoever's signing the will, and then the will is only valid when those two copies are put together. Again, it's rare that we use that, but at least it's an option if need be. Okay, number 6, I've heard a bit of, I guess, debate around this, but this is relevant for definitely the participants in this group, is that the court no longer rushes probate for real estate closings. It used to be that when you apply for probate at the courts, you put the signed agreement of purchase and sale right on the top there to let them know we have a closing date coming up, and that would typically rush the process, the probate process. As of this year, I haven't seen this in action. I haven't seen this proven yet from the court, so to speak, but they have said that they're not going to rush the issuance of a certificate of appointment of estate trustee of probate just because a real estate transaction is on the table. So realtors and everyone dealing with an estate property should keep that in mind. And I mean, I think there could be a whole course on this about how to prepare an agreement of purchase and sale for an estate, and how to deal with the probate for an estate, and then the sale of a property on behalf of the estate. There's a lot that goes into that, and if people are coming to me for probate, I warn them that it could take up to a year. There's no reason to rush the agreement of purchase and sale to have closing any sooner than that. Now, if probate comes sooner, great, we can make an amendment to close sooner, but there always needs to be a mechanism in there, a clause in the agreement that gives some leeway to the court, and to say we can only close once we receive the certificate. That's really what grants the executor powers to act. Number 7 is another big change, is that this, on application, the Superior Court can, what it means from strict to substantial compliance is validate a will. Now, if a will was not legally valid, one example I saw recently is the signatures were on the back of the will and not where they were supposed to be. The court can look at that and determine that, you know, it's good enough, substantial compliance, we're going to stamp the will as kosher, and you know, we can use the will. Beforehand, a minor error in drafting or execution would have made the will invalid. And again, people have testamentary wishes, and if the will's invalid, then they get stuck with the laws of intestacy, as we saw above, and that is not necessarily what people want. So this allows the court, again, to go in and say, even though the will isn't completely accurate or valid according to the law, we're going to give it a stamp of approval and allow it to be the last will and testament. So these are big changes. Estates Law 2022, as you can see, we've done a lot with wills, marriage, separation. We're not quite there yet with the digital signings, but I think we're getting there. And then these other last points, I think, smooth things out, and, you know, make it at least a more known process when it comes to the administration of an estate.